Afternoon to everyone and a warm welcome. And I would thank the ICSI IPA for inviting me for this session. Of course, the topic talks about behavioral changes under IBC, and I understand almost all the participants are insolvency professionals. So the basic understanding about the law is there. Since the law was enacted, I think it's been 7 years and it's been a roller coaster ride as far as IBC is concerned. And many of us who've been into this particular practice right from day one or maybe intermittently have seen the changes which IBC has brought about in the way the debtor-creditor relationship has changed, in the way uh, business in terms of corporate governance less reliance on debt, more on equity. So a lot of transformation has really happened in the commercial corporate finance space pursuant to the introduction of the IBC. Now, IBC is actually a very potent tool in the hands of the creditors because largely this is a creditor in control regime. If you leave aside the pre-pack, which is still a debtor in possession, unless the COC decides to keep the RP in control, but unless the except for the PIRP, which is the pre-packaged, the entire IBC regime is largely a creditors in control regime. And most of the issues that we see in terms of non-cooperation, so on and so forth, is largely on account of this creditor in control regime, where no one likes, especially a promoter, that a third party comes in, takes over control, custody, the entire power of the board of directors stands suspended. So no one likes that. And essentially, I would say the companies which have got admitted into CIRP obviously have a past. Some of them are in normal parlance repairable, where a resolution can be found. Even cases where liquidations have happened, unfortunately, assets could have been sold expeditiously in many of these cases. Thereby, these assets have been released to the market. I mean, new bidders have come in who have the wherewithal to run these factories, and they have taken over these assets, and a lot of productive changes are also happening. But having said that, we of course are seeing a large number of companies also heading into liquidation, as well as the change pattern in terms of a lot of operational creditors who were earlier filing insolvency resolutions, and a lot of withdrawals are also happening. Of course, the threshold of 1 crore has been a dampener as far as operational creditors are concerned, but that also has enabled a large number of companies to escape the clutches of insolvency for a meager 10 lakh, 15 lakh, 50 lakh a default. So in terms of the flow of my presentation, I would, since the topic is behavioral changes, so it would be my duty to look at what has been the pre-IBC regime recovery mechanism. So what all recovery mechanisms existed prior to IBC? Not everything has been repealed upon introduction of IBC. So some of these recovery mechanisms, resolution mechanisms do continue even after IBC coming into practice. In terms of the IBC journey, we'll have a look at what are the key preamble, key features of the code whereby we've seen this dynamic shift happening in terms of debtors coming and settling, the creditors of control, the committee of creditors taking control over the assets and trying to drive a resolution process, drive a process by which the corporate is saved from eventual liquidation. How have resolution applicants looked at the entire IBC process? Because the process is largely run for resolution applicants. Unless resolution applicants come and participate in the process or bid in the process, IBC would be a failure. And finally, the outlook as far as adjudicating authorities are concerned. Of course, the law has been enacted by the parliament. The parliament passed the law. Thereafter, legislation in terms of delegated legislation has been handed over to the Insolvency and Bankruptcy Board of India, the IBBI, which within its power under the code comes up with various regulations from time to time, including amendment. So a lot of paradigm shift has been seen even from the outlook of IBBI, understanding the needs of the ecosystem, trying and making suitable amendments, clarifications on a very timely basis. And wherever gaps are there, which is not there in the code or in the regulations, mostly interpretational issues, the adjudicating authorities have also played a very stellar role in explaining the gaps wherever jurisprudence had to evolve. Wherever there were gaps in terms of interpretations, various interpretations could have been done on account of the code and the provisions of the code as well as the market practices. So the adjudicating authorities have also stepped in and they have filled in the gap to the extent of creating jurisprudence. So largely, as my journey goes as an insolvency professional in the last 7 years, I've been fortunate to be one of the earliest insolvency professionals, and I've handled quite a few cases till now, both CRP resolution as well as liquidation. And we've seen the journey in terms of the shifts that have taken place, both in terms of legislation making, both in terms of behavior of the creditors, of the debtors, as well as the confidence which has come in the resolution applicants. A lot of liquidation cases are getting a lot of bidders, and most of the data also, as you suggest, IBBI uh, keeps on circulating information as far as the data of CIRP liquidation, the recoveries are concerned. So even that data, if you see, you'll obviously do understand the gradual shift. So with this, I will start my presentation. I'll also request the participants, in case you all want to speak, please unmute yourself, or in case there is some disturbance from one of the email IDs, I'll request everyone to be on mute, please. I'll request everyone to kindly put yourself on mute, please. Yeah, fine. Thank you. So as far as pre-IBC recovery mechanisms, avenues for restructuring, avenues for resolution were concerned, you primarily had recourse to various schemes under the Companies Act to 1956 and thereafter 2013. Then also to resolve stress, especially in large accounts, there were various RBI guidelines in terms of a joint lenders forum, a corporate debt restructuring. Thereafter came the strategic debt restructuring, the S4A, and the 5 by 25 scheme. So RBI also came up with various schemes right from, I think, 2015 onwards. A lot of action was seen because a majority of the companies which went into corporate debt restructuring between 2008 to 2012, 13, 14, a lot of these CDRs did fail eventually. So RBI did have to come up with various schemes, and finally what came was the insolvency and the bankruptcy code. The SURFACE Act 2002 and the recovery of debt due to banks and financial institutions. So this was also a potent tool, and this still exists, a potent tool in the hands of secured creditors or even bankers for a recovery of their dues. There are also ARCs which helps in resolution, because as a bank, your primary role is to lend. Your role is not to recover. Of course, recovery is a part of the entire process, but a bank can only handle as much recovery account. So in accounts where they feel that the banks should hand it over to ARCs where they're getting a very decent price, the banks do take recourse to asset reconstruction companies. We had the Sikh Industrial Companies Act, which obviously was known as the BIFR also, and this has been repealed once the Insolvency and Bankruptcy Code was enacted. So this particular Sikh Industrial Companies Act, BIFR, was actually, we can say, a lot of warehouse for a lot of defaulting entities to get protection under BIFR. But since this protection has gone, we've seen companies who've been there under BIFR protection for more than 5 years, 8 years. One of the cases that we resolved, the BIFR protection was there from 2008 onwards. So from 2008 till 2019, when the company actually got resolved, there was no action because there was protection under the SICA. Similarly, for insolvency resolution of individuals, there was the Presidency Towns Insolvency Act, there was the Provisional Insolvency Act. Both of these have got repealed. And there were also civil courts, commercial courts for recovery proceedings, which still continue. So most of these laws had a positive impact as far as a resolution was concerned. But however, uh, a lot of emphasis was laid by the legislation on the various RBI guidelines, the SURFACE Act, the ARCs. but nothing much did come out. It was a highly fragmented resolution mechanism with recovery rates of almost 23% and an average time period of 4.3 years for resolution. So looking at all this was the enactment of the insolvency and bankruptcy code. So in the last decade also, we've seen major reforms, especially with respect to two major reforms which has been brought by the current government. One is the insolvency and the bankruptcy code. Second is the GST Act. These are path-breaking reforms, and in due time, maybe we'll see the fruits of these legislations playing out. Briefly, I will touch upon what were the provisions so that when we move forward, there is some basic understanding. I understand many of you all do know about it, but I'll briefly touch upon what were the avenues available under the Companies Act. So the Companies Act had various provisions for revival, rehabilitation, compromise arrangement, winding up, voluntary winding up. So most of these have gone, but still there are avenues for compromise arrangement, amalgamations, which are possible. The last major deal which we saw and which did got fail under the compromise arrangement amalgamation under Section 230 of the Companies Act was the deal between the Future Group and the Reliance Group, which actually fell through. And a lot of these companies of the Future Group enterprises are now under insolvency and bankruptcy, and most of it is in public domain. I'm handling one of the companies of Future Group, which is Future Enterprises Limited. In terms of recoveries, I mean, it's there all over the news. So recoveries would be hardly any, is what banks are even expecting from Future Retail and from most of the future entities, because the business has closed down. So even compromise arrangement settlement is still as a resolution. So the point that is to be made is, for companies, creditors, even there is a settlement apart from IBC. There is a settlement which is possible. Lenders as well as debtors should look at their own individual positions while they look at taking a company into insolvency and bankruptcy. Most of the time, we've seen IBC is a threat now in terms of increasing 12A happening. A lot of companies also settling even before the petition gets admitting. So a lot of this data is also there in the public domain. So the Companies Act still is, I would say, a viable mechanism even for recovery, resolution. We've seen some compromise arrangements, amalgamations also happening through the Companies Act, even after the IBC came in. Some of them did fail and the companies did land up under the insolvency and bankruptcy. We also had the SICA. The only difference in SICA was there was a protection, like IBC has a moratorium under Section 14. SICA also has a moratorium under Section 22, which granted immunity. Now, this immunity essentially meant that no cases, no proceedings, no recovery of dues could happen. While IBC gives a very small window of 180 days, 270 days, 330 days, SICA gave an unlimited review, and that's where this got repealed, and a lot of delays happened because of SICA. Two recovery acts which are still there with the banks. One is the recovery of debts due to banks and financial institutions, the RDBI Act, which we call as 1993, and which was thereafter boosted by the SURFACE Act of 2002. So the recovery is generally the same, but under the DRT Act, as we generally call, you apply to the DRT and you take a recovery certificate, they would appoint recovery officers. But under SURFACE, the banks themselves can take possession of the secured assets. They themselves can take even control of the management of the business and appoint any person to manage the secured assets. So the SURFACE is a very potent tool. In fact, we have not seen much cases in terms of banks taking over management under SURFACE. But in one of my cases where I'm handling currently as the liquidator, the bank has exercised its right to proceed under SURFACE for two of the projects which are running projects. And mind you, handling a running project by a bank is very difficult. So technically, we have not seen many of the banks taking management control under SURFACE. What they take control under SURFACE is movable and immovable assets, and then they sell it by way of auction. So generally, instead of taking a management control, they would assign this to an ARC, which are specialized institutions which would deal with resolution, restructuring, handling of the corporate debtor. Then there were various restructuring options. I'll briefly take you through some of the restructuring options. Of course, this PPT would be shared, so it also is there as a reference point. The corporate debt restructuring was there in 2001, obviously for borrowers where aggregate exposure was more than 10 crores. This was essentially in many cases, which was seen was kicking the can down the road. You postponed today's problem to tomorrow under CDR. The immediate moratorium which was given to any corporate debtor under any CDR plan was to give a moratorium of payment of interest as well as principal for a minimum 1 to 2 years. Maximum 2 years was the thumb rule in many of the cases that we have seen. So for 2 years, there was no repayment of interest or principal, and thereafter, there was staggered repayment over a period of 10 years, 15 years, depending on case to case on and how much deep restructuring the company required. But a lot of these CDRs did fail because as IPs, we know any resolution plan which comes, we will have to look at the feasibility and viability. So even under CDR, the feasibility and viability was being checked at. So I think unlike the CDR feasibility, viability, which was more of allowing the banks to, I would not say evergreen the assets, but also a way of reducing the provisioning that they would have to take in the books. But CDR was a non-voluntary, non-statutory mechanism which was within the RBI purview. And a lot of other creditors, being operational creditors, used to approach the High Court and file winding up petitions against the company. So a lot of CDR did fail because these companies could not revive and eventually were under the official liquidator under the High Court. So there was no protection even in a CDR because you could only deal with the lenders. You could not deal with operational creditors. You could not deal with statutory authorities. Now, banks have also become a little bit more proactive. And in 2014, the RBI came up with a JLF and adoption of a corrective plan where when you look at signs of stress, even at that point of time, you will have to address the stress. So there was an SMA 0 classification, SMA 1, SMA 2. So even before the company went to the 90-day cycle of becoming an NPA, there was joint lenders forum, which was mandatory to be done once the company went into default. Similarly, an SDR was also allowed by which banks were allowed to take 51% stake in the company and to offload this stake over the period of 18 to 24 months. So even this scheme was adopted by in many of the cases, but it did not find much success. So was the change in ownership outside the SDR scheme. Thereafter came the scheme for sustainable structuring, flexible structuring of long-term projects. And finally, I think what currently is being done is the resolution of stressed assets via the June 7, 2019 circular. So the current restructuring, whichever is happening under the June 7, 2019 circular, which also seen a lot of litigation. So these were primarily some of the avenues which are there, which are still there. Of course, in the next slides, we will see a lot of data around IBC. But before that, why IBC and what are the salient features of the code? So in one of the publications which was published by the IBBI, the chairperson himself said that amendments to the code or regulations will not suffice. It is necessary for all the stakeholders to take actions in a time-bound manner. So IBC as a law is not going to solve your problems. It is not going to solve the problem of the corporate debtor. It has only been introduced to reduce delay and to maximize the value of the corporate debtor. So it is incumbent upon all the stakeholders to get together and facilitate a resolution in a time-bound manner, because you cannot keep the resolution pending for 2 years, 3 years, 4 years. The company would die a natural death. Even we've seen companies that we have taken over as a part of IRP, RP duties. It's very difficult to run some of these companies because of huge cash flow issues, no interim finance. So it's very important for you as the insolvency professional or the resolution professional to look at the resolution in a time-bound manner so that delays, if at all they are there, they are minimized to the extent possible. And it's very important for an insolvency professional to play the role of a facilitator by which you bring all the stakeholders together and try to push to a resolution in a time-bound manner. Finally, the commercial wisdom of the committee of creditors will prevail in any case, but as an insolvency professional, you will have to play a positive facilitating role. I know it's easier said than done. Generally, it becomes in many of the cases that we've seen, there is a lot of mistrust between the insolvency professional and the creditors and the corporate debtor. But somehow our job is to navigate to an extent that you try and take all the stakeholders together. So what was the objective of the Insolvency and the Bankruptcy Code 2016? It was basically to reorganize and insolvency resolution of corporate persons in a time-bound manner. So this was the first objective of the code. Second was to maximize the value of the assets, promote entrepreneurship, availability of credit, and to balance the interest of all the stakeholders. The reason I put this slide is because whenever you run a COC, it is always important to tell the committee of creditors that the preamble of the code is the most important. And in a lot of judgments, the NCLT, the NCLAT, as well as the Supreme Court has held that the order is also sacrosanct, that the first order is reorganization and insolvency resolution. So before maximization happens, you will have to give first chance to resolution of the corporate debtor. In many of the cases, the Supreme Court has opined that corporate debt liquidation should always be the last resort. The first chance should be given for insolvency resolution, regardless of the price that the committee of creditors are going to give. That's where the valuation is also done to give a benchmark. In many of the cases, even after an application for liquidation has been filed, the NCLT, the adjudicating authorities, have given additional time in case there is some other bidder who has come and shown interest. So in one of my cases, we had run the resolution process. There were resolution applicants. The plan was not to the liking of the committee of creditors. In their commercial wisdom, they rejected the plan and they filed an application for liquidation. While this application for liquidation was being heard, we got a couple of bidders who shown interest in this particular company. So while we could not give them time as an insolvency professional or the committee of creditors, because it is not within our domain or it is not within our powers, so we directed them to approach the honorable adjudicating authority. The adjudicating authority said that yes, since bidders are interested, we would want to give another chance of revival. So they gave the bidders 8 weeks time to do the due diligence and to submit a resolution plan. And thereafter, this resolution plan which was submitted by these bidders was then approved by the COC, and thereafter it was approved by the NCLT also. So the point that I'm making is, as insolvency professionals, the behavioral change will have to be driven by us. We will have to educate, or we will have to guide most of the COC members, stakeholders, resolution applicants in terms of what are their rights, what are their obligations, what are their duties. While commercial wisdom is sacrosanct, but it is also the duty of the COC to act in accordance with the preamble of the code. It is also the duty of a resolution applicant to not put terms and conditions which the COC cannot accept, which the adjudicating authority cannot accept. So you will always have to give primacy to insolvency resolution before maximization of the value of the assets of the corporate debtor. Thereafter is promoting entrepreneurship, availability of credit, balancing the interest of all the stakeholders. A lot of operational creditors, statutory authorities have been litigating even after the plans have been approved. So I'm not saying it is the mistake of the RP. The RP can't do much in many of these cases where litigation is inevitable. But your job is also to reach out to all these stakeholders, ask them to submit claims. Many of the times, if you see the genesis of the litigation, they say that we did not have information, so we did not submit a claim. And that's where the genesis of most of these litigation, especially from statutory authorities, do come. Now, the regulations have also been amended to say that it is the job of the IRP and the RP to reach out to all these stakeholders who are there in the books of the accounts. So wherever you see creditors in the books of the accounts, to the extent possible, please reach out to them after taking information from management. So you'll have to do all those efforts to reach out to stakeholders. So the objective of the code will also have to be kept in mind as an insolvency professional, either as an IRP, RP, or as a liquidator when you're running any processes under the code. So this essentially is a complete code, a single insolvency and bankruptcy framework, which takes care about corporates, LLPs, individuals, partnership firms, proprietary. The significant shift, most of the litigation, most of the issues, I think a lot of professionals also hesitate to pick up assignments because of the onerous responsibilities which is cast upon the resolution professional. Now, the latest order, which is of one of the high courts, which have now come in and which probably is also a cause of concern to a lot of practicing insolvency professionals, is the status as occupier. So they are saying that you are the de facto occupier. Of course, the entire power does vest in it, but as an occupier of the factory, there are a lot of onerous terms and conditions. If you look at the Factories Act, uh, you will have to be placed at the factory. So that's also one of the conditions. You should have knowledge about the laws, knowledge about the operations of the factory, and that is something which as an IRP or an RP, it is very difficult to have knowledge about each of the factories. And essentially, we are not stationed there in the factory. We obviously do visit, but it's not possible for us to spend our majority time at the factories. In one of my case also, the factories inspector did not allow because we were to renew the factory license. So they said the IRP or the RP will have to become the occupier. We resisted this. We finally went to the NCLT. The NCLT did opine in our favor, saying that yes, the resolution professional can appoint any professional to act as the occupier. He need not become an occupier. However, this particular order is now of the High Court, so it will be dealt in due course. So I'm saying the basic shift of debtor in possession to creditor in control is the driving factor which has changed the behavior. A lot of creditors never could control companies. So the moment you have the company under your control, the debtor is bound to come and speak to you. So in most of the cases where an OTS or a settlement proposal is being talked about, unless you threaten or you file an application under Section 7 or maybe a Section 9, if it is an operational creditor, the corporate debtor never takes you seriously. So this significant shift and the entire genesis, I would say, in terms of the issues that are there between the promoter, between the committee of creditor and the resolution professional is because of this shift from debtor in possession to creditor in control. So an IRP, RP or a liquidator is appointed. The committee of creditors will supervise him. You have the SCC, the stakeholders consultation committee. Of course, the views of the SCC is not binding on the liquidator, but they have the power to change the liquidator. So to that extent, they do hold some control supervision over the liquidator, while the overall supervision and adjudication and the under the IBC does rest with the adjudicating authority. The test has also been shifted. Unlike in a BIFR, there was erosion in net worth. Now it is payment default. Even a one-day payment default greater than 1 crore can land you into IBC. Even operational debt, financial debt, home buyers, everything, everyone has been considered. It's a time-bound process, 180, 270, outer limit of 330. There is a concept of moratorium to focus on resolution. I'm taking this a little bit faster because I'm sure everyone is aware about this. So the concept of moratorium also helps the resolution professional and the committee of creditors and the resolution applicants to focus on resolution of the corporate debtor. Needless to say, the entire control and custody and the management of the corporate debtor would vest in the resolution professional during the CIRP, would vest with the liquidator during the liquidation process. A significant insertion which has helped a lot of companies which essentially were under the scanner of the enforcement agencies, be it the CBI, the Enforcement Directorate, the SFIO, the EOW. Section 32A, the moment Section 32A came into being, a lot of these companies did manage to find good resolution applicants, did manage to maximize the value of their assets, because now it is very clear that Section 32 protection is available. It is only available once a resolution plan is approved by the NCLT or a liquidation order is passed. So to give you an example, I have been handling companies, and majority of my assignments are companies where either there is an ED attachment or there is an SFIU investigation or a CBI investigation. Once a resolution plan is being approved, that is the point of time, in our opinion, that you can file an application with the NCLT. So what we generally tell all resolution applicants is that a Section 32A protection is inbuilt in the code. You don't need to approach the NCLT. But yes, in your case, we would approach the NCLT. Once your resolution plan is approved by the COC, parallelly, another application would be filed by the RP for seeking immunity under Section 32A and removal of attachment by making the enforcement agencies also a party to this application. Both the applications would be disposed at the same time, the approval of resolution plan as well as detachment of assets. So this is the way you can provide confidence to a resolution applicant, saying that protection is available, because many of them would put it as a condition precedent, which generally in most of the COCs, the committee of creditors are reluctant to agree. Many of whom you are practitioners, while approval of a resolution plan, you've seen that the committee does not accept any of the conditions in terms of any conditionalities to the approval of the resolution plan, any condition which may lead to an uncertainty, both in terms of implementation, uncertainty in terms of receipt of the money, so the quantum as well as the timing. The creditors do hesitate. So it is your duty to convince both the committee of creditors as well as the resolution applicant to dilute some of these clauses and come to a common ground. Any insolvency petition is a representative suit. It can be filed by an OC, including workmen, stat authorities. Once the process starts, you can withdraw it through a 12A. Otherwise, the company would go through a resolution phase. If it does not get any meaningful resolution or no resolution plans are received, then the company would automatically go under liquidation. You have a pecking order under Section 53, which defines the way in which the money would be distributed. Another important feature of the IBC code is investigating into the affairs of the corporate debtor. So a lot of companies do not want to be investigated by an external party, by an officer of the court, and an application to be filed at NCLT. So a lot of settlements which are happening. So these settlements are being assisted because of creditor in control, because of the investigation in terms of the look back period of preferential transactions, undervalued transactions, extortionate credit transactions. So a lot of action has also been seen in terms of settlement, withdrawal, or pre-IBC resolutions, only because of the draconian clauses relating to the look back period and investigating the affairs of the corporate debtor. Withdrawal is always permissible under Section 12A. So I'll give you a very glaring example. In one of the cases that I was handling, I was the IRP in this particular case, and this was a large assignment. The debt size, even principal debt, was more than 1,000 crores, almost 1,600 crores of claims that had received from financial creditors during this process. Now, this particular corporate debtor was in discussion with the creditors for settlement. So the ideal settlement was some ARC coming and buying the debt of the corporate debtor. So 2 or 3 banks had settled at 30 to 35 paisa to a rupee. That is at a steep haircut of 65 to 70%. But one of the banks did not agree. I think the corporate debtor was offering 40 and they were requesting for 50, and that is where the negotiations were ongoing. But simultaneously, they also filed an application for initiating IBC, and after a year, this application got admitted. The corporate debtor, as expected, went to NCLAT and sought a stay, which was granted. Then over the period of next 6 to 9 months, this bank walked out with 83% of the book value. So what others walked out with 35%, they walked out with 83%. And there were some other four or five lenders, big lenders, who were there in this account. Of course, when one account got settled, because this was the bank which had filed the application, there was no COC which was formed. So the other banks were also settled thereafter. Of course, I was not a party to those settlements, but they have also been settled at 83% or more than 83%. So this is the transformation that IBC has gotten. I'm not saying that if IBC wouldn't have been there, banks wouldn't have been able to negotiate. But then, yes, this was one of the tool which the creditor used to his advantage. So creditors have also become smart where they want to get the corporate debtor to come and negotiate, come to the table, because on the table it is always has to be a win-win. Prior to IBC, they used to stall any SURFACE action, they used to stall any DRT action, and for 3-4 years there was no action which was seen under SURFACE or DRT. But under IBC, it's very difficult to stall. Generally, we've seen that cases do get admitted between 8 to 12 months. Now, with the latest benches coming in, we've seen some cases which have been admitted in less than 6 months. So IBC is not a punitive legislation, but it is an economic legislation. It is a non-adversarial legislation. And the only intent is to find a resolution, either pre-IBC or within IBC, you have no choice. There will have to be a resolution or a liquidation. So the idea is to maximize the value, do a timely resolution. So in terms of numbers, how do the numbers look so far? The IBC journey so far, this is the latest IBBI quarterly newsletter, which they have issued in the month of September. So as you can see from the chart which is there, in the last 7 years, 7,000 companies, the CIRPs have commenced by the end of September 2023. So out of this 7,000 CIRPs, almost 5,057 CIRPs have been closed till date. So 5,000 is a huge number in terms of closure. Out of this 5,000, 1,053 have been closed on appeal or review or settled. 947 cases have been withdrawn, that would be under 12A. 808 cases have ended in approval of resolution plans, and 2,249 have ended up in orders for liquidation. So essentially from 5,000, 2,250 have gone into liquidation. So that's around for 45%. So 45% companies have gone into liquidation, but 55% of the companies have seen a resolution or a settlement in one manner or the other. So this speaks about the effect which insolvency and bankruptcy code has brought into the relationship between a debtor and creditor. Earlier, the defaulter was in control. It was a debtor in possession. So the banker had to go to his office because he never used to pick up calls. You has to issue notices. Whenever he replies, you were dependent on him. But IBC has given you a tool by which you can unseat the promoter. So the promoter's seat is taken away. And I'm not saying that the IP replaces. The IP is just an administrator, is not the promoter. The IP comes in as the temporary mechanism, temporary administrator under the code, who's been given powers of the board of directors to ensure that the entire control, custody, the business is being run in an orderly manner, and finally a meaningful resolution has been put. So if you look at the numbers, even in terms of numerical numbers, I'm not going into right now the percentage recovery, the claims which have been settled, but only in terms of numerical numbers. Out of 2,000 companies are still work in progress. Some may go into resolution, some may get into liquidation, some may also get withdrawn as 12A. But almost 2,250 companies have ended into liquidation. That means the liquidators have started the sale process. So ultimately, these assets, these were commercial assets, residential assets, plant and machinery, whether in scrap condition or in good condition, or even land building, factory land building, these have gone to alternate usages or to the same usages which the corporate debtor was earlier continuing his business in. So almost 55% cases have got resolved one way or the other. The balance 45% of the companies which unfortunately went into liquidation have also found some takers. Now, the other feature other than CIRP has been voluntary liquidation. So we have the forced liquidation, which is an outcome of the CIRP process. We also have a voluntary liquidation. So at the end of September 2023, so this data is September 2023, 1,668 corporate persons have initiated voluntary liquidation. So voluntary liquidation is also a smoother, faster process for closure. Out of this, 19 processes have been withdrawn, almost 1179 final reports have been filed, and 470 liquidations are only ongoing. So only a minuscule one third, 33% liquidations are continuing, whereas two-thirds of them have also been resolved. And wherever the liquidations have been closed, the realization was almost 4,385 crores. I'm not saying that the promoters could not have taken out this money by closure through other means or by the Companies Act, but this money has also gone through alternative usages now. This money has also been released into the financial system, and this money will also find alternate use. The amount due to creditors was 46.66 crores. So what does it say is essentially most of the voluntary liquidations, the creditors are paid even before the process gets started. So it is essentially maybe sale, if not sale, it is closure of the company and repatriation of the money either to the overseas investors or to Indian investors. In terms of timelines, if you say almost 40% of these cases are more than 2 years. Almost 55% of these cases have seen a timeline of greater than 1 year. 45% of these cases have seen a closure within 1 year. So even in terms of speed, a lot of speed has also been got into this process. Now, as per the latest IBBI voluntary liquidation regulations, the processes will have to be closed within 90 days if there are no creditors, or if there are creditors, it has to be closed within 270 days. So IBBI also wants us to close these processes quicker. They want IPs to take quicker actions rather than sitting on timeline. So they would want the insolvency professionals to take quicker actions. As far as the forced liquidation is concerned, out of this 2,249 CIRPs which ended into liquidation, almost 1,652 cases are ongoing. So these are cases which are currently ongoing as on September 2023. Only 343 liquidations were closed by dissolution. That means a dissolution order has been filed. But in many of these cases, I believe a final report also would have been filed, because in 3 of my cases, I have filed final reports. We are waiting for the dissolution orders yet. 32 sale by going concern has been achieved. So when the IBC was enacted and the regulations were framed, there was no concept of sale of going concern under a liquidation process. It was essentially sale of the assets either in parcels, lump sale, or individually. But after the advent of IBC, looking at the market feedback, looking at what assets could have been gainfully sold by even during liquidation as going concern or by compromise arrangement. So you can see out of these 40 companies still have been saved by going concern sale or by way of compromise and arrangement. So as I've said earlier also, even the Supreme Court, NCLAT and the NCLT at various forums have held, in various judgments have held that liquidation should be the last resort, corporate dissolution should be the last resort. As far as closed liquidations are concerned, you can see the chart on your right in terms of the reasons for liquidation. Almost 1,500 cases, the COC decided to liquidate the corporate debtor during the CIRP. That means before the entire process could be closed, that is before 180 days, the COC decided to liquidate the company. In 665 cases, the no plans were received even after the entire process was being run. And thereafter, the RP filed for a liquidation. In 61 of these cases, the adjudicating authority rejected the resolution plan for non-compliance. And in 24 cases, which I would say is unfortunate, the corporate debtor contravened. That means the plan was not implemented. In terms of value, the liquidation value of these closed liquidations, which is essentially 343 cases, the liquidation value was close to 2,965 crores. And what could be realized was 2,850 crores. So that means almost 96% of the liquidation value, even for the companies which have seen liquidation closures, have been achieved. In terms of timeline, yes, I would say even in my cases, we've not been able to close some of the liquidations in a time-bound manner. It will always depend on the nature of the company. I have been handling an EPC company for the last 4 years. EPC companies are very tough to manage, very tough to sell, and assets were scattered. And this was during the peak of the COVID, which started. So, but other companies where manufacturing assets were there, we could close them within less than 6 months. So it all depends upon the nature of the asset and the marketing which you do as a liquidator to sell this asset. So if you look at the timeline, almost 55% of these ongoing liquidations are for more than 2 years. So that's a huge number. So as RPs, there are a lot of as liquidators, there are a lot of issues in the liquidation process. But I think a large amount of this, I'm not sure whether the data captures this, is submission of the dissolution application till disposal. So a lot of these cases are also the final reports have been filed, but the dissolution order is taking time. So I think with this, what I'll do is right now, I'll see if there are any questions in the chat box. So if there are any questions, please feel free to ask. Let us try and make this interactive. In case there are questions, please feel free to ask. I am not seeing any questions as of now. Any questions from any of the participants? Fine. So if there are no questions, we'll move on.
So there is a question.
Yeah, go on.
Sir,
Sir.
when you find out that there are say some investigation going on with by some authorities like ED, what as a resolution professional you are supposed to do apart from intimation to those parties that resolution process has begun?
So essentially, sir, there is nothing much you have to do other than cooperate. That is the only thing that you'll have to do. They'll keep on sending notices, ask for information, ask for phone numbers, addresses of directors, addresses of past employees. So you'll have to do diligent efforts to assist them. That's the only thing that you can do. I don't think in my cases, apart from that, anything else they are asking. They keep on asking data. There might be raids also, which would be conducted by the enforcement agency. So during these raid, they generally sometimes keep you informed, saying that we would need the office keys. So that's something which they do. And in a lot of cases, they would also call you during these raids to give your statement. So in multiple cases, most of these enforcement agencies would make you a party to, they would take your statement as the RP, IRP, or the liquidator. But a very interesting, this question has come. A very interesting fact is even after you demit office, so if the company has got successfully resolved, you've handed this over, still, since you were in control of the company, many times you see summons as a corporate debtor XYZ accused Avil Menezes. So that's something which is there. So you will have to file for discharge applications before the respective CBI court or the PMLA court. So all those issues are there which you will have to deal with at some point of time.
In case before commencement of the CRP 2 years back, if the records have been seized by them, and the suspended directors say that we don't have any records because they have been taken away by the enforcement directorate, are we supposed to request them to allow us access to those books of accounts?
Yeah, so if the books are not there, you will have to make that request to the enforcement agencies to provide documents. So that would help you. In one of my cases, in as early as 2018, we filed a non-cooperation application against the CBI for not giving information. The NCLT did pass an order, but the cooperation was not forthcoming. So the CBI, after some 3 or 4 hearings, someone represented and said, what information is needed, please let us know. We are willing to give. But even though we sent that request, nothing much did happen. But till that time, we had closed the company by way of a resolution.
Okay.
So the point that I'm making is even most of the cases where data is also not available. I mean, as the insolvency professional, will have to make the list of assets, list of claims, and try to put that in the information memorandum. Resolutions are possible in such cases also.
Okay. But if they are more than 2 years old, whether for PUFE transactions you need access to those books, or you can continue if the other data is available with the corporate data?
So if the data is available with the corporate debtor, it is fine. But if you need to do a transaction audit for more than 2 years, it is always better to ask that information, because at what point of time, what information you need, you never know. So it is better to ask for all the information.
Okay. Thank you,
Take
sir.
all the information, take copies. They generally allow copies.
Thank you, sir.
Yeah. Any other question from anyone? Fine. So we've seen some numbers in terms of CIRPs and the settlements that have happened. So as a part of behavioral changes, positive shifts in the behavior of creditors. So as many practitioners would agree that nothing succeeds like success. Everyone is happy when there is a resolution. No one is happy when the company goes into a liquidation. But needless to say, even in a liquidation, you can try and attempt to sell the company as a going concern. So even those positive cases are there. And I've seen in one of my case where we could not get a resolution, but in a liquidation, we got an amount which was much higher than what we would have got, even if a resolution plan would have come. So the point is that creditors would like to see success. Creditors, especially committee of creditors, of course, they will want to have a meaningful recovery, but at the same time, they'll try their best to negotiate, but they are also willing to close. That's been my experience. Of course, the experience would differ from person to person. COC is generally in a position to close. It's the duty of the RP also to market the asset, both to the resolution applicant as well as to the committee of the creditors, because you are the bridge in between both these parties. You unfortunately will have to play the role of an investment banker also. So this is an economic law, and you will have to evolve this through experimentation, and the code is no exception, in the words of the former chairperson of IBBI. So you will have to do trial and error. In fact, in one of our cases, we are doing, I won't say trial and error. It's a well thought about, well calculated move. So that's what we are trying to do. It's yet to come out right now, so I can't share details. So you can do a lot of trials and experimentation. Of course, most of them should be calculated decisions. Otherwise, it would lead to very lengthy litigations, and the COC will also have to trust you in terms of the path that you are showing them. So the creditors would like to see success. They would like to see earlier resolutions. So all three sorts of financial creditor, operational creditor, anyone can initiate this. Promoters have no say in the process. So the IBC gives a very simplified framework for initiating CIRP. What is to be seen? It has to be seen a debt and a default. A greater than 1 crore default is the must to trigger a CIRP. There is nothing else to be seen as far as a financial creditor is concerned. If it is an operational creditor, there should not be any pre-existing dispute. So the IBC is not a mechanism for recovery. It is a mechanism for a resolution. And the reason I'm harping again and again is because as IPs will have to play a very dominant role when we speak to various stakeholders, saying that this is a resolution process, recovery is just an outcome of it. So as operational creditors also, it's a very simplified process as long as there is no pre-existing dispute. It also gives the corporate debtor also a chance to put itself up for resolution. We've seen in the case of Goer, where they filed a section, where the management itself has filed a Section 10 application saying that now we can't handle this. This company needs restructuring. This needs a resolution. So they filed an application under Section 10. So I will show you data also in terms of what has happened, how many FCs, how many OCs, and how many CDs have used this mechanism under IBC to initiate a CIRP to find a timely resolution of the asset. So if you ask me, being a practitioner, I would always advocate IBC as the last option. Of course, I generally tell most of the creditors who come to me for advice, saying that keep this tool ready, and this is something which will have to be kept as a tool ready as an alternative, so that if a resolution is possible, you will come to know today. The corporate debtor, the borrower is going to come and do either an OTS or a resolution or something of the sort is what he will come and approach and do. In case the petition gets admitted, that means you have caught the bluff, that that means that the debtor was only coming here to buy some more time, to try and create some structures by which he could siphon off more money or wean out the assets or make the assets less attractive. So IBC, in my view, is a preferred mechanism for resolution of stress. OCs, if you look at the cases which have been done till now, financial creditors, operational creditors, and corporate debtors themselves, the most of the cases have been initiated by operational creditors. Of course, their share has now come down because during COVID, the threshold of 1 lakh was enhanced to 1 crore. So a lot of creditors may not, operational creditors may not have a 1 crore credit. So in that cases, you've seen a lot of FCs now initiating IBC. So as creditor confidence increases in the IBC as a mechanism for resolution, IBC as a mechanism for earlier resolution, maximization of value, you'll see more and more creditors preferring this option. So this chart clearly shows that the creditors are in control, although there is an option to the corporate debtor under section 10 to himself apply for insolvency, but of the 7,000 cases that we've seen, almost only 422 cases, that is almost, I would say 6% of the cases, corporate debtors have themselves initiated. Otherwise, majority of the cases are being done by operational creditors as well as financial creditors. So operational creditors have triggered almost 50% of the CIRPs, following by the financial creditors who've initiated 44.5%, and the balance 6% has been done, 5 to 6% has been done by the corporate debtors themselves. 80% of these CIRPs have an underlying default of less than 1 crore. So that essentially means that 80% of the CIRPs where the OCs have initiated, the default was less than 1 crore. And 80% of the CIRPs where the underlying default was more than 10 crores have been initiated by FCs. So in all COCs, we've seen that the FCs will rule because they would generally have 80 to 90% in the total debt. We've seen operational creditors' debt ratios to be very less, not huge in many of the cases, to be very insignificant, but financial creditors are the only ones who are left out. The share of the corporate debtors themselves initiating CIRPs have also declined over a period of time. A lot of these CIRPs also could not be initiated because of the COVID period relaxation, which was provided by the parliament. So the legislature had also provided relaxation during COVID, saying that any default during COVID period, you can never initiate a CIRP in respect of those companies. So this chart very clearly shows us that the creditors are in control. The creditors are generally in the driving seat. The corporate debtors have not used, unlike the US, where it is a debtor in possession. So you see a lot of companies themselves getting into insolvencies and bankruptcy processes. The prepackaged insolvency resolution has not seen much attraction from the corporate debtors, but I think in times to come, a lot of action will be seen under the prepackaged insolvency resolution processes. So this slide we've just populated to show you the recovery under IBC vis-a-vis the recovery under any other mechanism. So the code by far has been very successful in bringing about an overall in the entire resolution process. So a lot of actions have happened outside the IBC process. When I mean outside the IBC process is even before initiation, you've seen a lot of ARC deals happening. You've seen a lot of restructuring happening. You've seen a lot of OTS also happening. So a lot of these action which we are seeing is outside even the surface, outside even the DRT processes. What I've done is a comparison of Lok Adalat, DRT, SARFAESI, the MSMED Act. If you are an MSME, you can also approach the MSME councils under the MSMED Act. This is also a potent tool for recovery. And of course, IBC is also another potent recovery tool. So the data is a little bit dated, but it will also give you an indication of the amount of recoveries which are happening under IBC vis-a-vis the recoveries which are happening under various other mechanisms. So if you, this data is of 2019, 20 and 2021. If you see on the extreme right-hand side, which I've also highlighted in green, so the amount recovered under Lok Adalat is 5.6%. The number of cases are quite huge. These are very small cases. DRTs have been 4.2%. SURFACE has been 23.5%. So vis-a-vis SURFACE and the IBC, SURFACE did have an upper hand during the COVID period. Under the MSMED Act, this data was available on the MSME website. This is almost 22.7%. And IBC showed 36.5%. This is the data information. Current information shows around 32% under IBC. And the overall recovery was around 19%. So if you look at the data itself, IBC looks to be a preferred mechanism only for large transactions. In case of large defaults, it is always better to take recourse to the IBC. Of course, you can also go under the SURFACE, but under SURFACE route, you can only take possession of the asset, because we've seen lenders have been hesitating. They have not been taking management control under SURFACE. If in the event they have to take the option of a management control, they generally take the option of an ARC. So recovery under IBC, as this table shows, has been more as compared to any other existing mechanisms. So even creditors prefer, as I've said, to initiate recovery proceedings where the amount is, of course, on the higher side. So this is again the average of the cases in terms of average per case. If you look at IBC on the extreme right-hand side, it shows 142.7 crores. This number would be dwarfed by the top 12 cases, the SR Steel, the Bhushans, the ABG shipyards of the world, the JPs. So these were large assignments, large accounts which were pushed into the IBC by the RBI at the behest of the government. So probably because of this data might be looking in terms of 142 crores, but we've seen SURFACE actions not happening where lenders have to recover thousands of crores. They send it through the ARC mechanism. But now IBC is also preferred. So 142 crores average is also a very decent amount. If you remove these outliers, you will see at least 100 crores worth of these cases. And that's a good number as far as we are concerned, because many of these small defaults generally would lead to SURFACE action. Our suggestion to most of the lenders is that SURFACE should be seen as the last option. The first option you should try is resolution immediately when the company turns into an NPA. Of course, these are our recommendations, our thought processes as RPs, as professionals on the ground. But it is largely to be seen that creditors should try and look for an early recovery. In many of the cases we've seen, if you start the recovery mechanisms very late in the day, like even in SURFACE and DRT, the corporate debtor in many of the cases blocks the lender's efforts for more than 2 to 3 years. So an early initiation of IBC may see better recovery rates, may see faster resolutions, may see much more meaningful resolutions that we are currently seeing. Because over the last 7 years, a lot of jurisprudence has also evolved. The resolution applicants, by virtue of the clean slate, which was enumerated by the Supreme Court in the Ghanshyam Mishra case, that no liabilities can come after the resolution process has been achieved through the IBC process. So a lot of these jurisprudence have given confidence to the resolution applicants that their assets will not be attached after a successful resolution under IBC. No further claims they would be asked to pay after the IBC resolution process. So maybe in the next 5 to 10 years, we will see a lot of action happening under IBC. I can tell you the banks are looking at IBC right now as a very favorable tool, but that too after initial efforts of OTS, SURFACE, DRT. While we may advocate an early application under IBC, but at the same time, the banks also want to give the borrowers a chance. They say that we have a relation with the borrower. These are not early mortality cases. When I say early mortality cases, means cases which become bad within the first year of the banks funding them. So these are not cases which have gone which have defaulted in the first, second, or third year. These are cases which have defaulted after 5 years, 8 years, 10 years, 12 years of a credit history with the bank. So we would want to see what option the borrowers would want to give. And if not, then we would look at SURFACE. Then we would look at SURFACE or IBC. So this is what generally the creditors have been saying. But with the prepackaged insolvency resolution mechanism coming in, a lot of OTS can also happen through the prepackaged scheme, which is essentially a debtors in control. A debtor in control is also not going to deter a promoter from hesitating to apply under this particular package of insolvency resolution, which I would say. So in times to come, a lot of action is expected, and as IPs, we can see a lot of cases which we would be handling as IRPs, RPs, and in some unfortunate case, as liquidators too. So recovery under CIRP through the resolution plans. So as you can see from this table, this is the latest data which has been there as on September of 2023. So as against admitted claims of 9.91 lakh crores, the liquidation value was 1.87 lakh crores and the fair value was 2.92 crores. The creditors have recovered 3.15 lakh crores out of these cases which have got resolved through the CIRP process. As a percentage, this closely borders to around 32%, 31.85% of the admitted claims. Now, most of these admitted claims also have a huge component of interest. The reason is that interest is the only meter which will keep on ticking even when you are sleeping. So I will give you an example of a company which I was handling as an IRP RP in 2017. This company had already become an NPA. It was close to becoming an NPA in 2011, 2012, where the lenders took this under a CDR mechanism. The CDR failed somewhere in 2014-15, where after a 2-year moratorium, nothing came out of this company. So from a principal debt, which was 1800 crores, 1800 crores was the principal debt. This debt ballooned in 2017 when it was admitted into CIRP to 4,250 crores. During this period, there was only depletion in the value of assets. There was no accretion to the value of the assets because the company was hardly doing any business to sustain itself. Although the chance was given to revive under the CDR mechanism, but it failed. So when it entered into CIRP, the claims were 4,250 crores. We were successful in getting a resolution for this company within the stipulated 270 days period. But unfortunately, this was early 2018, and after 8-9 months of some litigation at the NCLT, which involved workmen's union, etc., the RA backed out. Now, this was allowed at that point of time by the NCLT, and the RA also allowed us to forfeit the EMD of 2 crores, which they had given. But when this company eventually moved into liquidation in 2020, the claims now are in the range of 6,500 crores. So the point I'm making is 1,800 crores of principal became 4,250 with principal plus interest became 6,500. So as the time elapses, the claims will get inflated. But if you look at the fair value was 2.92 crores. As against that, creditors have recovered 3.15 crores. So fairly, that's a very decent thing. So as far as so if you look at the liquidation value, also the liquidation value was 1.87 crores. So 1.87 lakh crores. They have realized almost 168% of the liquidation value. That means a company which is sold as a going concern is likely to be resolved faster, is likely to fetch you more value than a company which moves into liquidation. So this is a very encouraging sign as far as recoveries are concerned, 32% recoveries. But if you compare that with the liquidation value, it's almost 1.7 times. Most of these companies, as I keep on saying, are ICU cases. I gave you an example of a company which was in BIFR from 2008 to 2018 until it was resolved in 2019. So 10 years being into BIFR, the interest has only got accumulated. Now that the SICA has been repealed, BIFR has been repealed, a lot of these companies found their way into the IBC processes, and they largely, most of them have got, a large proportion of them have got into liquidation. So as we move forward now, we'll see healthy companies who have issues in terms of repayment of debt. They might take recourse to prepackaged, or they might also look at the insolvency resolution under Section 10. So a lot of these recovery rates will improve as we've seen a lot of jurisprudence as far as the cases are concerned. Recovery under liquidation, as I've already told in one of the previous slides, of the liquidation value, it was 96%, and of the admitted claims, it is almost 36%. Any questions any of the participants have till now? So as far as creditors are concerned, they are the most important stakeholders in the entire resolution process. Unless creditors have confidence in the entire process, you are not going to see them taking recourse to IBC as a means to revive, as a means to resolve, as a means to maximize the value of the assets of the corporate debtor. So it is very important that creditors get confidence, and the confidence would only be boosted once the entire ecosystem supports. It is also mutual. The creditors, if they have to look at better realizations, better recoveries, they will have to aid and assist the RPs and the corporate debtors by timely giving interim finance, by timely taking decisions on various matters, including approval of resolution plans, approval of various voting matters. So largely a lot of emphasis, a lot of I would say the responsibility of the entire process, to my mind, it does not lie on the IP, but it lies on the committee of creditors. They will have to really visualize in terms of what sort of resolution is possible. The IP has just come in. It's just 30 days. You know the company much better than any professional because you've been with this company maybe for the last 5 years, 10 years, 15 years, 20 years. You have a running relationship with this company. So as a creditor, it is your job to visualize what sort of resolution is possible. Your job is also to guide the resolution professional in case you feel that the resolution professional is not probably able to understand. So it's always a consultative process between the IP and the COC. I always advise myself and also my fellow professionals to always engage with the committee of creditors, a meaningful dialogue with the committee of creditors. You will have to get in that element of trust, because a lot of times as professionals what you speak, people take it at face value. So it is your job, by way of circulating notes for the committee of creditors, by way of circulating the minutes, the quality of discussion, the quality of data that you present for the committee of creditors, to take an information. You just can't say information is not available, this is limited information, please take decision. Committee of creditors are never going to take that decision. They are not going to put good money after bad money. Critical cost like security, insurance, etc., they would pay. But interim finance, it's very difficult. Even I have faced huge challenges while convincing creditors to approve interim finance. Even if they are not giving interim finance, an outside party is ready to give an interim finance, creditors are generally shy, they are generally hesitant because they don't want the value of the company to be depleted. They don't want further loss in the process. So it's very important that creditors have that confidence, and IBC, in my opinion, has proved a huge game changer for the resolution of financially distressed companies. Creditors' behavior in terms of taking companies early to IBC will be lot dependent on the success of IBC that we've seen in the last 7 years. We've seen out of the last 7 years, the first 2 years have only gone in understanding what the code is, what this animal IBC is all about, what it can do, whether it can deliver, not deliver. So everyone was on the fence for the first 2 years. From 2017, the first case which got admitted, to 2019, I would say everyone was on the fence trying to look at what this particular legislation is going to do about. A lot of lenders, many of them old school thought, a lot of corporate debtors a lot of promoters didn't think that IBC would take the kind of shape it has taken today. Even it was believed that the legislature would be quite slow, but the adjudicating authority has also been quite quick in providing much needed jurisprudence. So I'm saying that net, the entire confidence in the last 7 years have been to a large extent because of the resolution applicants, because of the insolvency professionals, because of the committee of creditors, and because of the adjudicating authorities and the IBBI as the regulator. The entire ecosystem will have to work. Then only the outlook of all stakeholders towards IBC is going to change. You need a robust insolvency framework so that the creditor is also comfortable by providing interim finance. Interim finance, even the market is willing to provide. If you are able to convince the operational creditors that your support is needed, you will see better recovery rates. If the company undergoes a resolution process, if the company keeps on running, creditors will also have to be given comfort that their amounts would be protected by way of treating them as insolvency resolution process costs. So it's very important for us to give that confidence to the operational creditors, the confidence to the employees, the confidence to the workmen that your efforts to revive this company, the amount of goods, services, the labor that you're going to put as employees is not going to go waste, because this company is going to see a turnaround in the quickest possible time. Because IBC protects creditors who supports the company during the moratorium period. It prioritizes the dues of these companies as insolvency resolution process cost. Interim finance has not seen much action, even though it has been given a super priority status. But I think as companies who are into production, into manufacturing, working companies, going concern companies are likely to get an interim finance than companies who just need interim finance for paying the RP fees, legal fees, etc. I don't think the market is right now geared up to bear costs like the IRP, RP fees, etc. So with increased time awareness, as I've said, it just 7 years, 2 years, people were sitting on the fence trying to understand what it is. Another 3 years were lost in COVID. Now we are recovering from COVID, but IBC in terms of numbers have seen 32% recovery rate. This add to it, I would believe almost 30-40% of this would be in the nature of interest only. So that means recovery rates are quite better if you compare to any other mechanism. So if the company is able to run as a going concern, you are going to see better recovery rates, which because better prospects of attracting resolution applicants would be there, and a lot of CRP cost burden will also come down because the companies itself would contribute to its positive cash flows. Any questions from any of the participants? I don't want to be seen talking, so I would request if you all have some questions, any queries, please feel free. So, okay, fine, no questions, so we'll move ahead. Now, we've seen in terms of creditors, how the behavior has changed, what confidence measures the creditors have got over the last 7 years. People who are sitting on the fence have now seen the potency as far as IBC is concerned to deliver the goods, because there has been a behavior of the debtors. Earlier, the debtors were very cold. The promoters will never engage with you. There was no meaningful discussion. It was mostly hype, which they used to say, okay, paisa aa raha hai, we are settling, it's about a month, investors are there, give us 2 months, give us 3 months. So most of it was just talks rather than any serious efforts by the debtors in looking at resolving their assets, resolving their defaults. Now the borrowers under fear and pressure to repay the loan, clearly because there is a behavioral change amongst the borrowers. So borrowers, what they are doing, they're addressing signs of stress. And I think this is by far the biggest achievement of IBC is concerned, the behavior of corporate debtors changing. more corporate governance being issues of corporate governance being addressed, issues like we cannot sit on an issue forever. Earlier, any consultant prior to IBC would say that the debtors will not be able to even step into the company at least for the next 3 to 4 years, because courts, judiciary in terms of surfacey actions were seen to be very slow. And as long as the company is working, even high courts were not passing liquidation orders. They used to give n number of chances to the debtors to rectify, get into a settlement plan with the creditors. The creditors being frustrated were forced into a settlement plan because time is of the essence. Time value of money, 100 rupees today versus 100 rupees after 3 years, 4 years, 5 years of protracted litigation. I would rather have that 100 or 90 rupees today rather than looking at 100, after 3, 4 years. So there is a huge pressure on the debtors also. There has been a drastic change in behavior. They're addressing signs of stress, and this can be very clearly seen in the in the evolving private credit. If you see the newspapers in the last 10 years, one of the companies which was under IBC or threatened to go under IBC, they have raised some 3,200 crores of private credit, and they have used that to settle their creditors. So a lot of action is being seen from the promoter side to address stress. So only those companies would come where there are structural issues in terms of market, production, business is unviable, the debt is unsustainable, so on and so forth. So those cases we might see coming in for insolvency resolution, coming in for haircuts, which they would need to keep the business as a going concern. So it's time to address. So as far as debtors is concerned, it's time to address the issues or to lose control. So this is the underlying message of IBC, that you manage your affairs, otherwise the creditor control regime would shift into. So the first issue is fear of losing control. Why would a debtor come and settle? A debtor will come and settle because of the fear of losing control. The moment you know that someone is going to come to your house and ask for money, at that point of time, you know that you're going to lose control, or you're going to lose your social estate or social status too. So fear of losing control is an essential feature of this particular act, where there is a shift of power to the insolvency professional. No one wants to lose control. No one wants to lose ownership. For many of these companies, the businesses have been their identity. If you look at some of the prominent names which were there into business, which were large noted names in the industry, now we seen them under insolvency action. So for them, I mean, I have been closely involved with some of the large groups. I mean, most of these promoters do lament the loss of business. Not so in terms of what's happening currently or what enforcement actions would happen, but they had built something credible. They had built something which was useful to the entire ecosystem, that would have built to the entire GD, that would have added to the GDP of the nation. So they look at themselves as partners in nation building. They also look at themselves in terms of thought leaders, leaders who have done something in the industry. So whatever has happened today may be because of issues of corporate governance, because they have not addressed issues in a timely fashion, or they thought that they would get away with it. No one thought that IBC would come in so fast. IBC would have so much of more power that the creditor in control, the debtors would lose ownership and control in a very expeditious manner. So they now know that a debtor in possession is not a feasible option. So it's no longer a feasible option. You can't keep creditors in waiting. Sooner or later, creditors who come at your door will have a foot inside the company, and they would manage the entire company. An important feature of the code, as I've said earlier, is investigating the affairs of the corporate debtor. So once you get into the structure of investigating, no one wants their dirty linen to be washed in public. So a lot of settlements would happen prior to initiation of insolvency, at the time of filing an application, or even after the cases have been admitted. Section 12A does come to your rescue, where you can settle with the creditors. One of the most important aspect is initiation of bankruptcy. Bankruptcy is more of the promoter himself being adjudicated as bankrupt. So that's also something which has seen a lot of litigation now that the Supreme Court has paved the way for personal insolvency cases to commence. Being declared as bankrupt is also one of the social stigma which most of the borrowers do not want. Ineligibility under Section 29A. When the code was enacted, there was no Section 29A. Borrowers thought, and even we thought, that a lot of restructuring now would happen under insolvency and bankruptcy, where there would be a cover of a court stamp. But immediately after the inception of the code, the government did realize that, and Section 29A was introduced, where it nudges the debtors to address their corporate distress at a very early stage. So it shouldn't happen that a corporate debtor who could not manage his own house, who could not timely address his own issues, is also given a chance to put in a resolution plan. So Section 29A, especially in the case of companies who are not MSMEs, the relaxation is only there to MSMEs. So at the time of a submission of a resolution plan, you cannot be an NPA greater than 12 months. So if you have got 12 months, if you're not able to set your house in order, you're not eligible to submit a resolution plan. The most important aspect, I think, is the remarkable shift which IBC has got, is the way people are looking at corporate governance. In some of the promoter-held businesses that were closely promoter-held, we've seen professional management coming in. Probably you may see that this is just a facade, one may say that, but yes, but as time come by, as the times pass, you'll see a lot of action on corporate governance, a lot of strengthening of boards, a lot of processes, internal controls being set up. You won't have dummy directors or dummy independent directors any longer. So a lot of boost to the entire corporate governance ecosystem is also going to come in because of IBC coming in. The fear of investigating, which may happen also. So a lot of independent directors who are sitting on the boards today, although do not have any direct executive or management control, but they would want to be a watchdog, so that tomorrow there are no investigation into the company whereby preferential, undervalued, extortionate or avoidance transactions or fraudulent transactions are reported by any insolvency professional in their case. Proactive settlement. So debtors, as I've kept on saying, the debtors are making their best efforts to settle and to avoid consequences of insolvency resolution or the bankruptcy process. So as far as the latest data which is there till August of 2023, this is the last available data, 26,518 applications which were filed for initiation of CIRP have been resolved prior to their admission. So even before the admission happened, 26,518 applications were withdrawn. That means they were settled. So almost 9.3 lakh crores were resolved before their admission. So these cases have been resolved even before they have stepped into the CIRP. So that's a huge commendable. Almost 9.9 lakhs resolved through CIRP, 9.33. So almost 18 lakh crores have been resolved through the insolvency resolution mechanism or by fear of initiation of CIRP against corporate debtors. Even MSME debtors, as I've said, that they're exploring options under the prepackaged insolvency resolution process. So this is also something which is being looked at. A lot of corporate debtors are also gradually, there is a gradual decline in Section 10 applications. As I've said, that corporate governance, fear of losing control, fear of investigation. So a lot of Section 10 applications are also not taking place because I believe that the debtors are addressing their issues. Even during the peak of COVID, we've seen a large corporate house in India resorting to a massive dilution in equity. Almost lakhs of crores have been raised by this particular corporate house by diluting equity. So essentially, we are seeing people are now deleveraging their balance sheet. They're not any longer sustaining on leverage, because if you have excess leverage, sooner or later, you will not be in a position to repay or timely repay your debts, because it's an economic cycle. Your business can always not have an up cycle. It will always see the down circle because of various issues which may be related to you or maybe related to your industry or maybe related to the country. COVID also was an exception. So people are now not looking at leveraging themselves. They're looking at deleveraging and also diluting equity. So IBC has seen a lot of positive shift as far as corporate debtors are concerned. A dramatic behavioral shift has been seen in the way corporate debtors are now addressing stress. As far withdrawal is concerned, withdrawal under Section 12 of the IBC as well as appeal accounts for almost 40% of the closed CIRP cases. So of the OC initiated CIRPs that were closed, almost 53% were closed on appeal, review or withdrawal, and almost 70% of all the closures were only by way of appeal, review or withdrawal. So only 30% of the cases have moved into IBC. A majority of these cases have been withdrawn or settled prior to any meaningful action under CIRP. Any questions? I am not seeing any questions.
No, Avil, please continue.
Happy to see you, sir. If there are questions, I'll be happy to take it.
And we are very happy that you are adding your personal experiences into all these things and telling us, I have encountered this, I have gone through this. So that is more enlightening for us.
Thank you, sir. Thank you. So withdrawal, I mean, as IPs, personally, we may hate withdrawal, but I think the withdrawals are in the larger scheme of things where parties can withdraw once the CRP is initiated. So whether by withdrawal or by a resolution plan, a resolution has been achieved, and that is something which we should all be happy about. So 54% of the CRPs were withdrawn by parties, where the default was less than or equal to 1 crore. So obviously, we've seen a lot of action in terms of withdrawals less than 1 crore, but more than a crore, more than 10 crores cases have not seen much action because these needs timely restructuring. So this is also a wake-up call for a lot of creditors who are looking at this data that borrowers are willing to settle, borrowers are also willing to restructure. So a timely restructuring by banks, a timely restructuring of creditors would also help the borrowers to find feet on the ground. Now, while we've seen the action from the creditors, the proactiveness from the corporate debtors, from the borrowers, now also a very key component of the entire resolution process are the resolution applicants. So obviously they are someone who would look forward to a certainty and finality of the process. No resolution applicant wants to sit on an asset where a litigation is ensuing for more than 12 months, 2 years, 3 years, because money is fungible. Money which is there today may not be there because you're always in business and business will present opportunities again and again. So I think in hindsight, as insolvency professionals, we would want to see all resolution plans being adjudicated and closed by the adjudicating authorities within a period of 6 months. Earlier, the better. But I think with litigation being there, 6 months would sound to be a very reasonable time. So even if all litigations, etc., and a resolution plan process is closed after its filing within 6 months, I think a lot of creditor confidence as well as investor confidence would come. Most of the cases we've seen a lot of Indian resolution applicants being there. A lot of foreign participants are still sitting, and it's a wait and watch approach for them. We've not seen also participation of a lot of funds, although there are a lot of distressed funds which are there, but a lot of funds which are their marquee names have not been. Of course, they've been there to look at marquee assets, but mid-level assets, we've not seen even marquee names in terms of funds or investors being there. Of course, the best of the Indian corporates we've seen participating in the resolution process, putting their own legal team, getting jurisprudence, as we can see in the SR case, we can see in the Bhushan's case, we can see in Ruchi Soya. A lot of these resolution applicants have also put in a lot of efforts to resolve the assets once they have gone into litigation. While we've also seen resolution applicants themselves being a cause of litigation, but I largely feel that resolution as insolvency professionals, largely we can get into a consultative role, play the role of an investment banker to look at what the resolution applicants are litigating about or does want to litigate about, because they are the last people who should litigate in the entire process, because they have no vested right in the process. So they would litigate if the process according to them is not being conducted fairly, is not being done in a or is done in a partisan way. I think after 7 years, most of us IPs who've been working on cases do understand that there is a formula by which the case will be taken through without litigation. I would say that I've been fortunate not to see litigation, or I would say many litigation in most of my cases. Most of my cases have not seen the NCLAT or the Supreme Court, except in one case, all the cases have been settled at NCLT. So, in the words of the former chairperson MS Sau, he says, an insolvency proceeding is like an orchestra where many constituents have specific roles. And I've been harping this, as professionals, we would have to look and play at our role in a very positive manner, facilitating the entire process, because it has to be a win-win for both the creditors and the resolution applicants. If only the creditors are winning and the resolution applicant is losing, that means that company will likely see litigation in the future, because a resolution applicant who's angry would find ways and means to spoke the entire process. So it has to be a win-win on the table. As the resolution professional, you are very closely associated with the entire process, right from making the information memorandum to the data room to the due diligence process to addressing queries of resolution applicants. While it's very easy for us to say that information is not available, I have filed a non-cooperation application, but making sense of data is something that we should be looking to do that. So a very positive step as RPs is we'll have to try and make some sense of the data so that the resolution applicants are able to see the value in the asset. Unless there is a value in the asset, no RA is going to come and bid. They are not scavengers at the end of the day, nor are creditors, in a very crude language, fools to accept any peanuts that is thrown into them. So the resolution applicant is a very important piece in the entire IBC process, and a lot of respect will have to be given to the resolution applicants. In a lot of committee of creditor meeting, we've seen that generally these are lenders, these are not promoters who are selling the company. So the people who are selling the company, the participant in the committee of creditors, are largely lenders, and they have been lenders all their life. So it is always important to see the perspective from which the lender is coming at and trying to simplify and explain it to the resolution applicants. So certainty and finality to the process is what would finally be the ultimate aim of any IBC process. Pre-IBC, IBC recovery mechanism I've just recapitulated here for the sake of all the participants. I'm not going to spend time over here, but these options are still, some of these options are still there. So an investor can also come in an IBC process. An investor can also participate in a process which is not an IBC process by getting into restructuring under various RBI schemes. An investor can also come and get an OTS done. So there are various mechanisms by which an investor can come, but if he's coming in through an IBC process as a resolution applicant, he is obviously coming in because he finds the asset attractive. He knows that under the IBC process, he is going to get a very clean asset. In fact, to most of the resolution applicants, I keep on saying that this is the most cleanest asset that you're ever going to get under any process. Even if you're going to buy the asset under a bilateral process engaging with the corporate debtor, of course, there would be reps and warranties which they would be giving you as a part of the share purchase agreement. But that can also go bad, and a lot of litigation will only ensue. But under IBC, the insolvency professional is the most neutral party. The committee of creditors, being public institutions, have nothing to hide. The most transparent process ever is what you will get. And finally, the courts and the jurisprudence is always there to ensure that a clean slate company is given. Your assets are not attached once the entire resolution process is there. So investors in the last 7 years, I would say in the first 3 to 4 years were largely shying away. But once the government pushed the top 12 cases, the top 12 cases saw a lot of litigation from a lot of heavyweight resolution applicants, heavyweight corporate debtors, and I would say equally heavyweight committee of creditors who pushed their way through, saying that we are not pushovers, we will not get cowed down by litigation coming from powerful borrowers. So these top 12 cases have given a lot of boost to the entire IBC ecosystem, to the promoters, saying that the creditors are at the door and they can step in at any point of time. So you better manage your own house. So for key advantages to a resolution applicant is basically a potential to buy a company at a very reasonable valuation and with no attached terms and conditions. So that's the biggest, I would say, is an advantage for any resolution applicant, as is their buy low, sell high. So most of these assets have very high potential. In fact, some of the deals which I've done through ARCs, we've been in touch with a lot of banks, and they have also raised concern that some of the ARC deals or the IBC deals have happened. People have just flipped the assets at 1.5x, 2x, 3x. So this is largely on account of data asymmetry. So this would happen because data is not there. Quality data it has not been provided to the resolution applicants, where they have undervalued the asset. There may be lesser interest in the entire process because of overhang on the asset or litigant promoter. So a lot of things are going to also determine the value of the asset. But to a large extent, I think 7 years have passed. Maybe in the next 3, 4 years, we can see rather clean processes, clean processes which are run in a very seamless processes would be there as we get more experience as insolvency professionals and committee of creditors. I have also mentioned clean slate, which helps improve recovery rates, because now it's very easier to tell a resolution applicant, this is the price you are paying. There is no other price that you have to pay. You're also getting a protection from past offenses by way of section 32 of the code. So under IBC, IBC also provides a platform for a business to be acquired through mergers, amalgamations, demergers. So even all those structures are possible. In fact, if you look at the latest, I wouldn't say latest, it has been 2 years that the CIRP regulations have also got amended. Earlier, it was only company as a whole. Of course, you could deal with the assets and deal with the entire company as a whole. But now it has been institutionalized by way of regulations itself, that you can do a cluster-based approach. So the cluster-based approach is also a boon. We've seen some cluster-based approaches being done in large entities, real estate companies. So a lot of innovation, imagination, which was there outside IBC, has now been codified into by way of regulations, by way of jurisprudence. You've seen the group insolvency. You've seen a lot of cross-border activity also happening. So resolution applicants can now see a very clear time path, a clear issueless acquisition of the company. Even capital intensive companies from infrastructure, power sector companies, these also can be bought by the investors at very competitive prices. Streamlined processes for MSMEs is also another right step. As I've kept on saying during my entire presentation, that pre-packaged insolvency resolution framework, this is something which will have to see a lot of action, a lot of confidence by the creditors to give that approval, because the stumbling block, as I understand today in my experience, is you need a prior approval of the creditor to kickstart a pre-packaged insolvency resolution process. And at that point of time, you will also have to submit a base resolution plan. So until the base resolution plan is to the liking of the creditor, he's never going to give you an approval. So while we've seen resolution applicants being interested in the CIRP process, while...
Avil, can I ask you a question here?
Yes, sir.
See, you have highlighted all the advantages for resolution applicants. But main thing is the availability of the data. That is availability of the opportunity. What I am saying that IBA, the Indian Bank Association, for those who banks which are selling under SurfaceE, they have maintained a portal. So anybody can go and visit that portal, and suppose I want a property in Bombay, residential property, I can locate, which is available for the sale. So same way, why not IBBI is preparing a portal for which projects or properties are under sale at any given time? Or are you aware of any other such portal?
No, I'm not aware about any such portal, but I believe all expression of interest which comes around is there on the IBBI portal. I think that suggestion is valid. That so even under liquidation, now that IBBI asks you to upload every auction notice, so I think these are steps now. Maybe it's a work in progress. I think we should see it sooner than later. But I think it's a very
Yeah,
valid
because that
suggestion,
will
sir.
improve the resolution. That
Yeah,
will improve the resolution.
I completely appreciate and take that point. But we've also seen, sir, a lot of, like I think in your cases also, you've been seeing the moment a public announcement is given, you at least get 3 to 4 inquiries. The moment a Form G is issued, you get at least 10 to 12 expression of interest. So all these things are also happening. So I think a lot of awareness by the investors themselves is there because not everyone is there in this market. A lot of people are still standing outside, and that is where I think the recovery rates are less. So I think that's a valid suggestion. I believe the IBBI would be looking at it. We are right now at the ICSI IPA platform. So I think they should also take note of this as suggestions.
Right. Thank you.
Yeah, thank you, sir. So as far as even giving chance to companies undergoing liquidation, sale of going concern. So all this is possible only when a resolution applicant is there. And even in sale as a going concern, we've seen that the entire structure of reliefs and concession, protection from past liabilities, etc. So that jurisprudence has also been evolved. It was nowhere mentioned in the code or the regulations that all such things would be possible. But the NCLTs, the adjudicating authorities have also stepped in at the right time to get in that jurisprudence to provide those reliefs and concession. Otherwise, as a liquidator, you can also give all that things in writing, but generally it is always better if it comes to from the NCLT. So almost 32 companies were closed by sale as going concern under the liquidation process till now. So very important is the outlook of the adjudicating authorities. As I mentioned that wherever gaps were there in the legislation or in the regulation, those gaps were filled in by way of adequate jurisprudence, timely jurisprudence by the adjudicating authorities. So the adjudicating authorities have also stepped in and played their role towards boosting and augmenting the entire ecosystem as far as IBC is concerned. They've also understood that this is an economic legislation. The behavior of an adjudicating authority, as we see today, prior to admission is to try and give a chance at reconciliation, settlement, etc. That's what we've seen. Even in companies where the admission has happened and the promoters or the ex-directors or the company management does go to the NCLAT are very proactive in giving a stay whenever they are seeing that some settlement talks, etc. is happening. So in large number of cases, we've seen that those stays are happening. The adjudicating authorities do give time, even in Section 7 applications for some settlement, OTS, etc. So the outlook even of the adjudicating authority is resolution. So the behavioral aspect of IBC in terms of resolution, timely management of stress has even been seen in a lot of jurisprudence and adjudication of cases by the honorable NCLTs. So I'll just spend a couple of minutes on the regulatory regime under IBC. So under IBC, you have the Insolvency and Bankruptcy Board, which takes care of the IPS and the IUs and also the insolvency professionals. You also have the adjudicating authorities for corporate persons and the adjudicating authorities for individuals and firms. So the entire regulatory regime has also played a mammoth role in the way the IBC ecosystem has developed or shaped till now. A lot of restructuring has also taken place prior to IBC. So if you look at IBC, the NCLT has also come up with information. Of course, this is some dated information a year back. This is August 2022. So if you look at the number of cases which have been adjudicated and the number of cases which have been disposed of by the NCLT are quite high. So almost 85% of the cases as on August 2022 have been adjudicated. So almost 31,203 cases have been filed. So we'll not get into those numbers because these are just statistics, but we would also look at the constructive role which has been played by the adjudicating authorities in shaping up the entire IBC ecosystem. So the system was stabilized largely, I would say, by IBBI, which is the regulator, by coming in with timely changes, and the legislature as well as the adjudicating authority in the initial years. Otherwise, as insolvency professionals, especially for people like me who started very early, I mean, we were kind of lost in some of the cases in terms of what is the right action to be taken. Of course, you do have legal counsels, you have creditors where you can consult, but at the end of the day, it was new even to IPs, even to creditors, and even to legal firms. So the adjudicating authorities also stepped in at the right time, and a lot of these issues, as the IBC progressed, these issues started getting resolved. I think early on, we've seen in the case of Innoventive, the Section 7 petition, which was the first admitted petition, went right up to Supreme Court, where the Supreme Court said in the case of a financial creditor, what has to be seen is only a debt and default. There is no case of a dispute there. In the case of Section 9 petitions, largely a lot of dispute-related issues were seen, where NCLTs refused to admit petitions, saying that these are not recovery. This is not a recovery forum. If there is a pre-existing dispute, you should go somewhere else, get into a mediation, arbitration, conciliation, whatever, but don't come here. Come here only in case there is a clear case of debt, there is a clear case of default, which is above the threshold, there is a clear case of no pre-existing dispute. Then only Section 9 petitions were there. There were challenges in terms of the constitutional validity of the code and the various provisions. So even the constitutional validity of the code was challenged in various cases. So be the Swiss ribbons judgment or the K. Shashidharan judgment, these Honorable Supreme Court did upheld the constitutional validity of the code and the various provisions. The difference between an FC and an OC, why an OC does not require a seat on the committee of creditors, committee operational creditors being given the minimum liquidation value or the value as per the plan was also being upheld. So a lot of provisions of the code were being upheld. Ineligibility under Section 29A for resolution applicants, stopping early litigation by resolution applicants, saying that a resolution applicant does not have a vested right until the committee of creditors take a decision one way or the other. Till that time, they just can't come and litigate. So a lot of these jurisprudence were set in by the Honorable NCLT, the Honorable Adjudicating Authority, from time to time. I think the major one was Section 29A. I think after this judgment, which came in the Arcelor New Metal case, which was primarily the SR Steel case, a lot of activity in terms of settlement, OTS, restructuring, the behavior of debtors underwent a very drastic change after the order under Section 29A in this case did come. Applicability of moratorium on business operations. So what would form within the realm of moratorium and what is not moratorium? What is a contractual obligation? What is not a contractual obligation? Just to give you an example, in one of the case of where a power PPA, power purchase agreement, was terminated on account of insolvency, the NCLT NCLAT and even the Supreme Court held that you cannot terminate this contract which is the entire heart of the corporate debtor. Without this, the company will die a natural death and go into liquidation, you cannot terminate this on account of insolvency was one of the landmark judgments which come. While in another judgment, it also upheld that a contractual obligation, a termination on account of a contractual obligation not being performed by the corporate debtor does not fit within the provisions of moratorium. So they have protected both the corporate debtor, whereas they have also protected the customers so that as insolvency professionals, we do not take undue advantage by citing moratorium on every case. The binding nature of a resolution plan, now that the resolution applicants cannot walk away from a resolution process, so that's also a major relief for a lot of processes. That has given some certainty, saying that at some point of time, the company will find a resolution unless the resolution applicant does not have money to pay. So the binding nature of a resolution plan on all the stakeholders, the promoters, the guarantors, the operational creditors, including the statutory authorities. So everything has been clarified by the adjudicating authority, bringing in a lot of clarity, bringing in a lot of certainty in the entire insolvency resolution process. The concept of clean slate, the inter se priority of claims among the statutory authorities. We've seen the Rainbow judgment. We've also seen the Raman Ispat, Paschit Vidyut Uttaranchal judgment. So we've seen both the judgment in terms of the inter se of priorities. We've seen the clarification on payment of provident fund, gratuity fund, pension fund. In a CIRP process, it has a different connotation. It acquires a different connotation in a liquidation process. So if it is unpaid PF, even during CIRP period, whether contribution is made or not. So during CIRP, and RA will have to give a treatment on the plan. Every PF, gratuity, pension dues will have to be paid. Whereas in a liquidation process, if there is no separate fund, a liquidator cannot be made to shell out money towards payment of provident fund gratuity. Unfortunate from an employee workman perspective, but that's how the jurisprudence has evolved. So the adjudicating authority has also played a very constructive role in the entire jurisprudence and the entire ecosystem. Some of the notable innovative approach. So a lot of uncharted territories like group insolvency, it is not yet addressed. A very earlier case was the Videocon, where 15 companies went into the insolvency resolution process. I was also fortunate that I was a part of this process, where out of 15, 4 companies were there with me. So when this process started, they had a common management, common information system, common people, common customers, common interlinked facilities. So a lot of interlinkages between the facilities and the companies, the brand held by one company, the marketing by another company, logistics by another company. So this was a very classic case where the NCLT, in a very detailed order in August 2018, passed a 14 principle yardstick for determining eligibility of consolidation. So for group insolvency, this was one of the first detailed orders passed by the Mumbai NCLT. So these were passed under a discretionary power. There was nothing written in the code. There was nothing in the regulation. They have taken recourse or some guidance from foreign for jurisprudence available in foreign territories. So this was one of the first cases which saw group insolvency being tested, and this has been a successful resolution. Even in this particular 15 companies, 2 companies were kept out of the resolution process, giving some reasons to it. So not that everything was consolidated. So it's a beautiful order which most of the practicing IPs should read. There were several other orders, especially in terms of real estate companies, which talked about a resolution because some company owned the land, some had the development right, so on and so forth. So real estate itself is a very complicated resolution process, unlike any manufacturing or EPC company. So all these complications were in a large number of cases settled by the honorable adjudicating authority. So I think the group resolution to start with was for one of the first innovative approach into uncharted territories, thereby paving the way for resolution. I think out of this 15 companies, only one company went into liquidation. Otherwise, almost all the 15 companies, there was a chance could have gone into liquidation because you could not have done a separate resolution process for each companies. As I've already said, project-wise resolution of real estate companies. So this was also in various landmark judgments. This, I believe, is also being addressed by the regulator by way of amendments to the code. A lot of consultative papers are there, especially relating to real estate companies. The home buyers also getting a seat on the committee of creditor. That was the landmark in the JP Infra case. So a lot of positive developments have happened, thereby boosting the confidence of the entire ecosystem into the IBC space. Even cross-border insolvency issues were being addressed. Extension of CIRP after 330 days. While the code was very strict, and in the SR judgment also the Supreme Court said that after 330 days it will compulsorily head into liquidation, but thereafter into numerous judgments it has been held that corporate death should be the last stage. So liquidation should be the last resort. So in many cases, we've seen extension of CIRP even beyond 330 days in the spirit of achieving a resolution. So in at least at least four of my cases where even the 330-day period has been elapsed and voting was underway or negotiation was in the final stage, the NCLT did give time right from 40 days to 60 days. In one of my companies, after an initial 60 days, we are asking for another 45 days, which is currently being heard by the NCLT. So in the spirit of resolution, especially MSME companies, large companies, companies which are going concerns, the NCLTs have been quite looking at all these issues very positively. A preference to PRA participation, as I've said, that even a company where a liquidation application has been filed and some PRA comes in asking for a resolution plan to be submitted, the NCLTs have been even accommodating such request, where I've also said in one of my cases, the company did see a resolution in that case where a liquidation application was filed and a bidder came in asking for time to submit a bid. Sale of going concern, as I've already said, reliefs and concessions, which is not there in the code or even not there in the regulations, which NCLTs are now granting. And most importantly, I think this is a very important thing which jurisprudence has helped is recognizing the importance of commercial wisdom of committee of creditors in decision making. So a lot of things can now be brushed under the carpet of commercial wisdom. You say anything, I think the defense by the COC and the defense of the RP in many of the litigation is this is the commercial wisdom of the committee of creditors. However, commercial wisdom should also be linked with some judicial wisdom. But as I've always said in numerous seminars that I've taken or study circles, that the COC as a body is a very smart body. They are commercial people. They also understand a lot. There is a lot of consultative process which goes behind every COC meetings in the banks or in the management of the committee of creditors. So their commercial wisdom has been upheld by the court, and a lot of litigation has now reduced because the COC's commercial wisdom has been taken as sacrosanct. So even the adjudicating authority has played its part in basically giving jurisprudence where it was much required clarity to the entire IBC process, by which only one thing has happened is the borrower has no escape route. The behavior has to change. There is no escape route which has been given in any of the cases. So finally, there is one question in the chat box which says, is there a judgment on the status of employment contracts upon commencement of CIRP moratorium, particularly when there is no communication from IRP regarding suspension or termination of employment? So as I understand, in a lot of companies, we had factories which were not operational just prior to CIRP or maybe prior to CIRP, but employees have not been terminated. So under the Factories Industrial Dispute Act, if you have to terminate workmen employees, there is a process to which has to be followed. There is retrenchment, compensation, so on and so forth. So the Industrial Dispute Act, especially related to workmen, is quite protective. You cannot just terminate employment of workmen. But yes, employees you can terminate based on the contractual agreement that you have. So I think largely the case would be in case of a company where there are no operations, but employees are there, workmen are there, what do you do? So in most of these companies earlier, there was no clarity on what is to be happen. So we used to tell the employees no work, no pay. A lot of litigation also happened. We used to give them on furlough. So this has now been upheld by the Supreme Court in the case of ABG Shipyard, where they have said that only those people who are required for keeping the company as a going concern, only those costs will be CRP cost. So a lot of cost or a lot of CRP burden has reduced because of this. So this judgment is the Supreme Court judgment in APG Shipyard. I think this is Sunil Jain is the citation. Just check this. So better if you terminate the employment, then you will have to pay everything which is contractually payable to them. So the advice which most of the lawyers give is you should issue a notice of no work, no pay, give furlough. And whomsoever is essential, you only keep those people who are essential. That part, that cost would become insolvency resolution process cost. I believe I would have answered your question, sir.
Yes, sir. Yes, sir. Just one more clarification, sir. What happens that typically, especially in case of a senior management, because the IRP in the initial phase require a lot of support from the senior management. So the senior management continues to report. Earlier they were reporting to board of management. Now they continue to report to the IRP. So and normally the senior management has a very high salary package. So this is a particular case when it was not a factory, but one of the senior managers was getting paid in lakhs and lakhs. He continues to report to IRP. Then IRP suddenly says after 6 months that, oh, you are not a part of the essential service, I'm not going to pay. So what happens in these kind of scenarios?
So see, at the outset, this is wrong. I mean, if someone works for 6 months, whether he was required or not, should have been decided on day one. So till the time you tell no work, no pay, you are bound to pay and you are bound to honor the terms of the contract. So the only way to do this is there are two ways of looking at it. I'll tell you in one of my case, what happened was we had senior management. This factory was working. We had a CFO who was a director of the company. We had a factory head, plant head who was also a director, and we had an administrative head. So all these were independent people. These were not promoters. They were not shareholders. Also, they were independent people. Now their salaries were, I don't want to use the word high, but their salaries were decent. It might look high to you. It might look decent to me. For someone else, it might look like peanuts. So that's a very, I would say, a very touchy issue, and we are no one to decide and opine once the company has. So it is on the face of it very high. Then obviously you can term it that it's quite high. But in our estimate, it was reasonable, commensurate to the size of the company. Now, since these were directors, as an IRP, I could have ratified their fees because it was a related party thing. But the moment a COC was formed, their fees, their salary was to be ratified because they were working directors, director being a related party. So we put it up to the COC and the COC refused to ratify that cost, saying that this is too high, make this half. We went back to them, we tried negotiating, but they were adamant saying that this is not high. I worked for 30 years and this is fine. This was few lakhs. So we came back to the COC saying that they are adamant, nothing doing, but since they were directors, so they resigned. And since they resigned, they continued as employees because they were employee directors. So we continued their employment because they were needed for going concern of the factory. Now the CRP refused to, the COC refused to treat this as CRP cost. So naturally, after 2-3 months, we could not pay them. So these guys went to the NCLT. The NCLT said that you all were directors, you all were ex-management, and the COC is within their right not to treat this as CIRP cost. So till the time they were directors, they were treated, their CRP costs were not ratified by the COC. The NCLT upheld this. They went to the NCLAT. The NCLAT also did not find anything vague in the NCLT order, and this was upheld. So ideally, till the time they are working, you will have to honor that. But you will also have to see whether the COC approves this or not. So there are no right or wrong answers, whether the salary is right, salary is wrong. Someone may also say that the fees that you are drawing as an IRP is too high or too low, right? So it's all subjective at the end of the day. So it's always better to communicate, look at whether the costs are sustainable, not sustainable, whether some amount can be taken, some reduction can be proposed, some amount can be taken by him now, some amount can be taken as insolvency resolution cost payable at the time of approval of a resolution plan or liquidation. So you have to sit with them, try, negotiate, understand, but he also has an option to resign. If he resigns, would he be able to manage the operations of the corporate debtor efficiently? That is also a question that needs to be answered by you. So there is no right or wrong answer, but various IPs will have various experiences to share, and you will always have to look up to guidance to the COC members. I hope I have answered your query, sir.
Yes, thank you, sir. Thank you.
Any other question from any other person? Fine. So I have come to the end of my presentation. Of course, it was a 3-hour slot, but we are at 4:15 now. So if there are any questions, I
Sure.
will take those
I-
questions.
I have a question, sir. In case of a unit which is closed since past 2 years, and there are still ESI returns being filed with a list of say around 10 to 12 employees, and they're filing their claims, though nobody is attending the office because the unit is closed since last 2 years. So how to deal with such kind of claims?
No, so essentially, if workmen are there who've not been terminated, factory is closed, you issue a notice of no work, no pay, and that's an acceptable practice.
But the claim relates to previous period where the unit was not
It's
in
fine.
CRP.
The claim is fine. See, at the end of the day, since their job was not terminated, I mean, there are two things that you can look at. You can reject it. They can go to the court of law. Ultimately, they will say if the contract has not been terminated, as per the Factories Act. See, I mean, it was the duty of the employer to give them work. If the employer fails to give them work, so out of 30 days, if I don't give you work for 2 days, do I give you only 28 days salary? So that's the argument. There was no work, factory was closed, but someone should have terminated, someone should have taken that effort, someone should have said furlough, strike, something under the applicable laws. If nothing has been done, as an IP, I would accept their claims for the period up to insolvency commencement date. I would ask the management for a response and I would accept their claims. And for the period after initiation of CRP, I would institute no work, no pay. I mean, that's the easier way of looking at it.
Thank you, sir.
Can you share your experience about early dissolution of the company, CD?
Yeah, so early dissolution is also possible. So there are two aspects to this. One is early liquidation and then is an early dissolution. So you can take the company, the COC can take the company to liquidation before completion of 180 days. It can also happen in the first meeting. The regulations allow, the code allows, you'll have to record reasons in writing. And thereafter, once the company heads to liquidation, you can also move in for an early dissolution. The condition is if there are no assets and the liquidation cost would exceed, there is no one to pay the liquidation cost, provided you don't have anything to investigate in the company. So as an RP, you will have to give a report saying that there are no avoidance transactions, no transactions in terms of preferential, undervalued, extortionate, etc., etc. You can give that, and then it can move to an early dissolution. I have seen one order of the Chandigarh bench, I don't remember the case, from CIRP directly went to dissolution because there was nothing to liquidate also. But if you look at regulation 13 or 14 of the liquidation regulation, it says that early dissolution is possible if there are no assets to pay the if the liquidation cost is more than the realizable value of the asset and there is nothing to report, no fraud, nothing.
Okay, thank you.
Yeah, thank you, sir. We have time, we can take questions.
Sir, in one of our cases, the matter is pending before NCLAT.
Yes,
The
ma'am.
status quo is being maintained.
Mhm.
So now the company is a going concern. CD was a going concern, but now there is no activity as such. So can an RP, I mean, take a decision to run the factory on, I mean, maybe on a lease basis?
So I understand the CIRP was admitted. The promoters challenged the admission order
No,
at
no.
the NCLAT.
Withdrawal application was filed. Then the settlement was not done. So one of the COC member, I mean, they were the major COC members. 100% shareholding was the COC members were there. So I mean, they said they want to continue the CIRP as settlement is not done.
No, but there is a stay in the NCLAT, right, ma'am? As I understand from your.
When the matter was heard in NCLT, when the settlement is not done, we have said to the adjudicating authority. They said okay, and that IA was disposed of. Then the CD went to the NCLAT.
Is there a stay? There is no stay. Just to before answering a question, I need to understand that. Is there a
There is
stay?
a status quo. Yeah, stay is there.
Stay is there, right? So the stay would be either on COC or the stay is on the CIRP.
CIR.
If the stay is on CIRP, that means, in my humble opinion, IRP has no role if there is a stay on CIRP. But if there is a stay on COC, that means the IRP stays. And the entire control, custody, everything happens. Moratorium is there. He continues to run business, take decisions. He can do everything without any COC guidance. Because if there is a stay on the COC, that means you can't call any meetings of the COC. That your job is then to, as an IRP, you have to run the operations, exercise management control custody of the assets. All decisions will have to be taken by you. So to give you an example, which I gave in the during the course of my presentation also, in one of the cases where I was appointed as the IRP, the management got a stay on the 15th or 16th day itself before the formation of the COC. And this stay continued on for almost 8 to 9 months before he finally settled, and he came out of the process. So for the entire 9 months, it was being run under my control. And this was a fully operational company, more than 2,000 employees, almost 200 crores turnover per month. So it was fully operational, and all decisions were being taken through me.
So in this case, it is better to be, silent.
If the factory can run, why not? If the factory is not operational, you can take your call.
It can run. It has a good capacity. Everything is in machinery is good. Everything is there. The
So if
only
it
thing
can-
is that whether as an RP or a COC can file an IA and they can proceed further, no?
No, IA for what? COC has no role. If there is a stay on COC, COC has no role. Factory is now your baby. You will have to either run it, close it, but you can't sell it. That's it.
Okay. Thank you, sir.
Yeah. Any questions?
Sir, I have a question.
Yes, sir.
In one of my case, it's a holding company. It has given advances and it has taken advances between the related parties. Now, whether and these are advances that are given for more than 5 years, but they are static for 5 years. What is my view like?
Can't hear
What do you do in this case?
I lost you in between.
Sir?
You said the advances were given for more than 5 years. Thereafter?
So there are advances received and advances given to the tune of 200 crores between related parties. Funds came in and funds went out. So in this case, and this advance is static for more than 5 years.
Right.
So as an if you are an RP in such a case,
Again, I lost you in the end, sir. If you are an IP in this case, what action will you take?
would you go for forensic audit?
No, so essentially, if it is a holding company, the object of any holding company is to invest. So
Yeah.
it would have invested in the subsidiary or an associate company by way of shares. It could have
Yeah.
also given loans, right?
Yeah. Yeah.
Now, if the purpose is right, because this is a common corporate structure. If I'm the holding company and I have 5, 6 operating companies in that, I would support these companies. So you will have to look at essentially what was the purpose of the loan, what was the documentation. There would be a board resolution, there would be detailed notes on why this is given and whether this investment is recoverable or not. If it is not if it is recoverable, that then it is one scenario. If it is not recoverable, was it a business loss? Was it siphoning? So in all cases, it is always better to do a transaction audit. So at least
Okay.
as an IP, if you are not equipped to give opinions on it, it is always better to do a transaction audit, get an external opinion, and thereafter base your opinion on that. So not everything
Okay.
is a fraud, not everything is correct also.
Okay. Okay. Thanks.
Yeah, thank you, sir.
One more question, sir.
Yes, sir.
In my case, if the CEO the forensic audit, what should be my stand?
Actually, you're not audible, sir, unfortunately.
One second. Am I audible now?
Yeah, clear.
If the COC is not ready to pay for the forensic audit fees, what should I do as an RB?
So your job is to get quotes. If you feel that there are transactions which are in the nature of preferential, undervalued, extortionate, fraudulent, your job is if you are capable to do it on your own self, or you ask for quotations from external firm of auditors. Put up the quotes to the COC for approval. The COC will approve because at the end of the day, if there are any fraud, siphoning, etc., that has happened, the benefit of these transactions will come back to the COC. I have not seen, at least in my cases, that the COC has been reluctant to saying don't do it. I don't think any bank is going to say that. That's my opinion. But it's always better to keep this documented, even if they don't approve, because unless they approve the cost, you cannot appoint the auditors. So in case if there is a deadlock, you can go to the NCLT, file a progress report and say that this is the status. The COC is not approving. What am I supposed to do?
Okay, thanks. Thanks.
Any questions? So if there are no further questions, I can pass it on to the moderators. We still have half an hour. I'm willing to take questions if there are any.
Can the new financial creditor, who is the sole 100% in the COC, can he ask for COC meetings where even after filing liquidation application, which is pending before the NCLT?
He's
Can he
asking
insist for a COC meeting?
for a meeting of the COC.
Because already resolution was passed earlier, who was earlier financial creditor, 100% voting power. And now the new asset reconstruction company in the place of this financial creditor insisting for fresh COC meeting when application for liquidation is pending.
See, in my view, there is no harm, sir. You can always call for a COC meeting because till the time the CRP is officially not closed by way of a liquidation order or a resolution plan, if there are some concerns, I mean, in case your company might be closed, but there might be company which is a going concern and there are certain decisions which might need the approval of the COC. So it is always better. You can call. I don't think there is any harm in not calling a COC. I don't think the regulations bar it explicitly. I have been calling in my cases.
Okay.
Because your job is to be as transparent as possible. I mean, if he wants to discuss something, why not hear him?
Okay.
Sir, one more question.
Yes, sir.
In my case, there was an RP who was there because of the NCLAT stay order for more than 200 days. He appointed the forensic auditor. The COC did not approve the expenses. So if I come in as an RP after 200 days, can I change the forensic auditor or I have to continue with what has been appointed by him but not done because the fee was not paid by the COC?
So it is your independent opinion because the COC has no role to play in appointment of any professionals. Their job is only to ratify the costs. Unless they ratify, you cannot appoint someone. So in case you feel the need to change the auditor, you can change the auditor or you can appoint another auditor with additional scope. All depends.
Okay, okay.
Any further questions from any of the participants?
Sir,
One
in
more
case of
question, sir. One more.
Yeah, please.
If COC wants to go for liquidation before issue IM, is it mandatory to get valuation of assets done?
No,
Okay.
you can do it in the liquidation process.
But it will have to be done in liquidation process. No?
Yeah, and if they want to go for liquidation, you should always tell them, let's do a valuation, at least the time will be saved. I don't see any harm in their allowing that.
Sir, regarding valuation, in case the asset details are not known, whether still values have to be appointed because you don't know which class to appoint other than land and building, or you wait till the assets are made known to the RP?
So appointment of valuers is for each separate class of asset. So if you have details on land building and plant machinery, go ahead and appoint that. As and when SFA details are there, you appoint them.
Okay.
It will all depend, or generally what we do in such cases, appoint an RVE at a consolidated fee. So you don't need to go back and again to the COC because you will never be able to get all the data at one point of time. Data might come in 1.5, 2 months, or maybe it might come sooner or even after filing an application with the NCLT for non-cooperation.
So actually, that application is pending and still the details are awaited.
Which is okay. That's why I said it is always better to appoint valuers for the details of the asset which you have. You can take that quote from them.
Okay, and for rest we can appoint upon becoming aware of the other assets.
Yeah, that's what you can do. There are cases where we've seen that even though details were there, in one of my case, the corporate debtor gave details, the main promoter had died. So there were professional directors and his son who said, I have not engaged in the business. So they had given details about the asset. After the entire resolution process was over, the COC approved the plan, we filed it in NCLT. The ED attached assets of the entire group. So they sent me an attachment memo, provisional attachment. In that, I found out 2 more assets belonging to the corporate debtor.
Okay.
So all possibilities are there. So we appointed a valuer. In that case, since the entire process was over, we called a COC and we said, this is the case now. Now we filed an application with the NCLT also, asking for removal of attachment, saying it is bad in law. But at the same time, in the COC, we minuted they saying that we would value the assets and we would offer the RA first, right of first refusal to him at an X discount to the liquidation value or fair value. And if he refuses, then the COC would deal with that asset on his own. So that is what was agreed. Fortunately, in our case, the RA agreed to pay for those assets, which we noted in the NCLT. So I'm saying that many situations may come. Your job is to close this in a time-bound process. So do it as diligently and as practically possible.
Thank you, sir.
So one more question.
Yeah.
What happens? There are two scenarios. I receive a claim in CRP but no claim in liquidation, and I receive a claim in liquidation but not in CRP. How to deal with those scenarios?
Accept both. That's it.
Okay, but okay.
If
So
someone
even
is
if I
filed-
don't receive a claim in liquidation, I have to accept the CRP claims which were there.
regulations are clear now. They are deemed to be accepted.
Okay.
So can adjudicating authority can refuse if stakeholder committee also accept the lower bid, which is below the valuation amount. So can adjudicating authority has power to reject that offer when stakeholders are ready to accept it.
So this would be a private sale.
This is a private sale, yes.
Private sale will need prior approval of the NCLT. I think before going in for a private sale, you will need an approval from the NCLT. That is the regulation.
Okay. So earlier public notice was issued. So this particular buyer is interested in accordance with that public notice.
But at a lower amount, you can't do that.
Lower amount is valuation amount. At that time, reserve cost is, yes, of course, high. Yes, so it is lower amount, yes.
If the reserve price is 100 and the auction fails, if it is the first auction, you can reduce it by 25%. Subsequent failure, 10% max. Those are the regulations. So if it fails at 100, if someone comes and says, I want to buy at 85, and the stakeholders are also willing to do that, then it would need an NCLT approval, in my view, because that's a private sale. But
Okay.
if someone comes and buys at more than 100, maybe 100 rupees, 50 paisa, 101 rupees, you can sell that by way of private sale because the regulation allows that. Less, not even a rupee you can accept.
Okay, thank you.
So one more. If a claim, hello.
Yeah, go on.
If a claim is received after maybe 100 days of the ICD, what is the stand now? We have to, as a RP, we have to go for continuation of delay to NCLT or what?
So the current regulation says claims can be accepted up to 90 days of ICD or date of issuance of RFRP, whichever is later.
But
So,
if there is no RFRP, then?
no, RFRP will have to be there, no? Are you not going to run a process?
Because there are only, I'm a holding company, so there is no, I don't see anything. And we're
It's
thinking
not
of
for you to
liquidation
decide.
actually.
It's basically it's not for you to decide. The COC will have to decide for liquidation. If the COC decides for liquidation, anyways, you'll do that before 90 days. So if it is going to liquidation, you can accept the claim at that point of time. There's no need to get into the condonation because the condonation would be there only if a resolution plan is being put up.
Okay. But in my case, sir, I was appointed after 200 days because of the enclad stay. So in this case, what can we do now? I have got a claim and after this September 2023 regulation amendment, we have to go, and there is no resolution possible in my company because only a paper company on the paper.
As an RP, you should not say that.
Okay. But I'm seeking your advice actually.
Then that's why I'm advising you. As an RP, you should never say resolution is not possible.
Okay.
Yeah. So anyways, in your case, for the stay at enclave, you need to file an exclusion.
So now,
Sorry?
Yeah,
Can you
tell me.
repeat, sir? I just lost you.
For the stay of enclave, you have to file an exclusion, sir.
Okay. Yeah.
so now they have changed regulation 12.1. So now beyond 90 days also, if RFRP has not been issued due to some stay on Form G, you can still accept claims because it only says that you need to take reasons for delay. And the last date is now whichever is later, RFRP or the date of 90 days.
Yeah, that's what I'm saying. If you are going to issue an RFRP, so it will be the date of issuance of RFRP. Anything received after that, then you need to apply for condonation.
Okay.
So I think, ma'am, we are done almost.
Conclude now. Avil sir,
Yes, ma'am.
shall we conclude now?
Yeah, we should conclude.
Okay. Thank you very much, sir, for such an informative and insightful session. And looking forward for more sessions with you. And all the participants, thank you very much for joining the session.
Yeah, thank you, everyone. Thanks a lot.
Thank you.
And now the next session will be on 27 December. And link will be same.
I'll exit the meeting, ma'am.
Thank you, Avil ji.
Yeah, thank you, sir. Thank you.
Thank you very much, sir.
Thank you, sir.
Yeah.